Okay, this is the meeting of the Zoning Board of Appeals for Monday, February 2nd. Present at the meeting, Mr. Jones, Mr. Keeman, Mr. Curran, Mr. Kimball, Mr. Winnett, Mr. Blas, and myself, John Goldrosen. This meeting's being recorded in accordance with the town bylaws and will be posted on the Whitman Hanson Community Access cable site. So we don't have any hearings tonight, just to bring people up to date on the future. And I didn't pick up the minutes from Cal, so we don't have any minutes to approve. We have a meeting on the 23rd. We have one case, a full hearing for 16 Washington Street, which is old house, currently 2-family. They want to make it a 4-family. And then just got an application in today for a parcel on Alden Street where they want to put an accessory dwelling unit. First application for that. So I think they'll put that, it just came in today. So I'm planning on a meeting for March 23rd, if that works for people. But also on February 23rd, this is a little tentative, the owners of, or representative for 66 Pond Street, which, you know, it's come up and gone down and come up and gone down at the end of Industrial Way. They have some new people on board and they want to come in and make a presentation. And so tentatively, we'll do that on the 23rd after the hearing, but I'm still going back and forth with them. I just want to make sure they have something substantial to come in with, that they've looked at the bylaw requirements and know what they're doing.
But that's part of the MBTA.
Yes, so hopefully that's what they're looking at, but I'm just not sure. So I just want to make sure that they're not just.
So that means they're going to clean it up. The environment.
That would have to be part of it. Yeah,
that'd be awesome.
Yeah. So
if it's right there on the corner, though, does that parcel on the corner have
That's
contamination, or is it back further?
Are you talking about the furniture refinishing place?
No, I thought you were meant up by Essex Street.
No, at the end of 66 Pond Street, at the end of Industrial Way.
Yeah.
Yeah. So if you go down where the barber shop is, the little one.
Yeah.
Down that street.
Okay, so it's on the south.
It's on the back.
Yeah, south end,
Okay.
south end of Industrial Way. Yeah.
So they're not really down like with a fence off everywhere, the bigger building further down.
Yeah, that's fenced off just because of the construction.
Yeah.
But that building is supposed to be sprinkled, and I can't imagine that it is.
Yeah, probably not.
Anyway, this would just be an informal discussion to give them some feedback. It would not be, an advertised public hearing, but it would be on the agenda, so it's still public and open. Okay.
Gonna be here the 23rd. What?
Yeah, and
I won't be here either.
on which day?
23rd.
February? Okay.
I'm gone until the.
Yeah. Okay. So let's see. We got 2 gone.
I'm here.
Okay. So we'll still have 5, and Tim Travis should be here. Okay. I just want to make a note of that. And Bob Curran, you're away until?
I'll be back the 3rd of April.
Okay. And Ed, which?
Just that Monday.
Okay. Okay. So the purpose of this meeting was to go over some zoning bylaws, but I did want to quickly go over just couple of basic things about zoning, because we've got new members and we kind of throw you into it with no education, no background, and I feel like just a couple of quick basic things. So we have people applying for different permits, special permit, variance, and site plan approval. So I just want to go over that. So in the zoning bylaw, towns divided into districts. Certain uses are allowed in some districts and not in others. Where it's a P in the zoning bylaw, that means that the use is permitted, and we say it's permitted as of right. Okay, So it doesn't need a special permit or variance from us. But I'll get to site plan approval in a minute, but pretty much all commercial buildings and anything more than a two-family building needs site plan approval, so they still have to come to us for that. But if it's a P, that's all they need. Special permit means, it's allowed in that district, but we get to look at it, and if we think that even though that use would generally be allowed in that district, it's not suitable for that particular site, we can deny it. But otherwise, we tend to approve it, but it gives us a chance to review it and impose, conditions. I mean, the one that comes to mind where it was a proposed liquor store on Bedford Street where the auto dealership is, near the corner of Forest Street, allowed, it's commercial district, allowed in that, or highway business, whatever, it's allowed in that district, but they came before us and there was neighborhood opposition, proximity of the school, and there were things about the site that we just think didn't work, so we turned it down. But we need to turn it down for a reason related to zoning, the impact on traffic or noise or whatever. We can't turn it down because there's another one of the same business across the street, and we don't want them to have competition. Okay, we can't turn it down for that reason. That comes up with auto dealerships. We may feel there's too many in town, but we can't really look at it that way. The selectmen can. The selectmen give any auto dealer also needs a license from the selectmen, and they have some degree of right of saying there's just too many. But there actually was a court case a few years ago which kind of limited them too.
So we can't put a moratorium on the number of licenses.
Yeah. So that's special permits, basically. The other thing we deal with is variances. So if somebody wants to have a use which isn't allowed in that location, either as of right or by special permit, or they want to put up a building that doesn't meet all the dimensional requirements that we have in the bylaws, the setback requirements and so forth, they have to get a variance. And that's stricter. We can pretty much say no, though we want to have still some zoning-based reason for doing it. And the State Zoning Act is pretty strict on what the requirements for variance are. It really is supposed to be, particularly, it doesn't say much about what use variances would be, but for dimensional variances, the State Zoning Act really says it's got to be related to the soil, shape, or topography of the lot. And soil meaning, if there's wetlands, say, on one piece of the lot, maybe you got to have the building, moved to where it violates a setback because you're trying to avoid the wetland. Or if there's a steep drop-off, that would be topography. Shape is not supposed to be something where the person who created the lot created the problem. So if you hear us throw around something like, well, you created your own problem here, we're not going to give you a variance. I think it's fair to say that this board, I've been to towns where zoning boards are very strict about this. And no matter how good, an idea it is, and how much the neighbors have no issue with it, there's really nothing objectionable about it, raises the property tax revenue for the town. There are boards that go strictly by that state rule and turn anything down that isn't really a wetland or, steep slope or something like that. And it's fair to say that we are more lenient than that. And we all have our reasons. My feeling is as long as I don't see a problem with impacts on abutting property and it's, good for the town. And I'm a little more skeptical when somebody comes in who bought the property a month ago. I think we all tend to kind of like look at it and say, well, geez, they've owned this property for 40 years. They're not buying in and trying to buying it low because of limits on the property and trying to get us to approve something more. So, but just so you know, I mean, a variance is stricter and supposed to be a bit stricter.
We do see a number of applicants come in, their hardship is financial.
Yeah.
That's the kind of the sticky wicket.
Yeah. Then that, yeah, again, somebody buys a house and says, gee, got to tear it down and put up a multifamily house because I'm not making enough money on it. Well, you bought the house, you know what you bought. I do think there are times where the occasions I can think of where we've taken financial considerations, financial issues into consideration are ones where like it's going to be it's redeveloping a decrepit property or a property that's contaminated, needs to be cleaned up or whatever, and it's going to cost more money to build on that property. And we have sometimes said, okay, you can have more units than we might have approved otherwise because
it's beneficial to the town.
Yeah. I mean, I can think of when the neighbors all said, oh yes, please approve this, get this mess cleaned up, even though it was going to be a multifamily structure, So, yeah, strictly speaking, again, shouldn't really take finances into account,
right.
But there are cases.
State law doesn't allow us to, correct?
Yeah, it doesn't, it says where these particular conditions like soil and topography impose a hardship on the owner. And so some say, well, it's financial hardship, but strictly speaking, no. Again, we tend to be a bit more lenient. Other states are more lenient, like New Hampshire's variance law really puts the burden on the board to show why they shouldn't approve it, because they're so concerned. Part of the reason for allowing variances is just to give some flexibility, because you do have to be concerned about takings, whether the requirement of the zoning is imposing violates the Fifth Amendment against taking private property without compensation. So, you can't just zone a property for conservation because you think it's a good idea if there isn't some sound ecological reason for doing it. And then the last thing we have is site plan approval. And this is one, if you look in the State Zoning Act, you won't see a word about site plan approval. It's just sort of happened and been created, and the courts have allowed it to a certain extent. But the notion of it really is supposed to be that we look at this application and we consider, kind of check it off to make sure it meets all the zoning requirements. But we're allowed to consider things like traffic and impacts on the neighborhood and so forth. The board isn't really supposed to turn down a project for site plan approval unless there's no way to remedy it. So you're supposed to work with the applicant and try to fix it a little. And I think you've seen that's sort of the approach we take, is what can we do to improve this a bit. So it's a little bit of an uneasy thing because it's not a special permit. But I think we sometimes use it to job on people, actually, to try to, the neighbors, first of all, by having special permit, we have a public hearing. So neighbors get to come in and say, well, if you're going to put a second floor in that building, could you not have the windows on the side facing my swimming pool? Try to work out things like that.
What's the cheapest way to build it versus what's the best way to build it? And those are the two we try to balance.
Yeah. Well, you saw, with the car wash, for instance, trying to make some adjustment to address the issues at the Toll House condominium complex. So that's just sort of the basics. I guess another basic thing is just to explain when we talk about the State Zoning Act. So we've got, our zoning bylaw, right? But there's also the State Zoning Act, Chapter 40A of the General Laws. And it's a weird kind of law because it's, well, zoning goes back to the 20s, but the State Zoning Act really particularly goes, in its modern form, goes back to the 50s, and then there was a major revision in 1975, and then things have been tacked on since then piecemeal. And originally it was called the Zoning Enabling Act because it was allowing the towns to do this. It's just called the Zoning Act now. So as a result, there are things in the state zoning law which says what the towns can do and are allowed to do. And then there are things that say what the towns can't do. And sometimes it's not too clear where the boundary is between them, or if the State Zoning Act is silent, does that mean you can do it? Or does that mean, well, no, if the State Zoning Act didn't allow you to do it, you're not allowed to do it. So our zoning bylaws incorporate some of the requirements of the State Act, just sort of to make it easier for people and the building inspector to know what the whole universe of the requirements are. But there are things in the state zoning law that we don't have in our bylaw, and so people kind of need to, and the building inspector needs to know how those work together. And then the last thing I just wanted to cover was enforcement, because this is something that differs from other boards. When the Conservation Commission gives an order of conditions, which is the permit under the Wetlands Protection Act, Conservation Commission has enforcement power. Somebody doesn't obey that permit, they're the ones responsible for looking at it, for imposing fines if that's necessary, for issuing an order to stop construction, to remedy the situation. They've got the power to do it. When the planning board approves a subdivision and says, lay out the roads this way and here's the quality of construction, the planning board oversees that. And if the applicant, the developer, doesn't obey, the planning board can refuse to allow the lots to be sold. So they have enforcement authority. We don't have enforcement authority. When we approve a permit, it's the building inspector who has enforcement authority. And we can, alert them to situations that come up. But if people come and have a complaint, that's why at these meetings we're saying, go talk to the building inspector. Because, we don't get to interpret it. The only way that we get to second guess the building inspector is if somebody can appeal a building inspector's decision. If the building inspector denies a building permit, and it's for zoning reasons, the applicant can appeal that decision to us. Or if the zoning inspector takes enforcement action and somebody disagrees with that, they could appeal it to us. Well, if the zoning building inspector fails to take enforcement action after being asked to do so, and he refuses to do it, the person who asked for the enforcement could appeal that to us. We haven't had too many cases, maybe one or two cases over the years where that's a decision has come to us that way. But in that case, we get to second guess the building inspector.
But if we say no and we turn something down and it gets appealed, every one of you will be sued individually. Just so you know.
Yeah, just so you know, if this happens, this is a requirement of the State Zoning Act. There's sort of if our decision gets appealed, there are different requirements versus, if you want to somebody gets sued for personal injury, there's 3-year statute of limitations to bring the suit, and a whole different court procedure for filing the suit and serving summons and all this stuff. Zoning law, it's intended to be a more rapid situation because you don't want things hanging in limbo. So when we make a decision and file with the town clerk, if somebody disagrees with it, either the applicant or an abutter, they have 20 days to file an appeal in court. So it's a very short period. And when they file that appeal, they name the zoning board, obviously, but they name all of us individually and they mail you a copy of the appeal. And that's really intended just as kind of a short, so they don't have to get a summons and get a sheriff and serve it on the town, this and that and the other thing. It doesn't mean you're individually liable.
It will be
But-
registered.
Yeah, it'll be certified.
It'll be a certified.
It'll be a certified letter. So don't worry about it. You don't have to go get your own lawyer. To get sued, if you do something that violates the civil rights laws and you get sued for that, like deny an applicant, and you sit here and you say why you're denying the application and it's for a reason that would come under the civil rights law, you could get sued. So please don't.
If the appeal is won, does the project stay under the building inspector, or does the state now oversee the project? So like for conservation, if they were to appeal, the town loses authority
Yeah.
to state the deed.
No, because you're operating under the State Wetlands Protection Act. You're sort of the first line, and if it's appealed to the state gets to second guess you, basically. That's not the way it works here. This is still strictly a town issue. All right, that's as much as I want to spend time on it, but I don't know if there are any questions. I mean, obviously you kind of learn by osmosis here, but I feel like those are kind of basic things that it's not fair to have you sitting there without knowing the stuff.
There are specific things on a site plan that our bylaws say must be on all site plans. Now, there were times when, over the years, especially like with Wayne, where if everything that our bylaws said had to be on that site plan weren't on that site plan, he would potentially vote no, just because something wasn't on the site plan. We've been pretty flexible with that.
Yeah, and that's when I talk about zoning bylaw changes. I mean, there's our bylaws, and one of the reasons I think we're flexible in variances, particularly, is our bylaws are just way out of date. I mean, they haven't really been changed much since 1960 or whatever. There have been amendments along the way, and where the zones are just doesn't make sense in contemporary economic situations. And one of the things, again, the site plan requirements we have make a lot of sense for, a shopping center coming to us. Not so much sense for somebody putting an addition on their house. And we try to be flexible. I think the building inspector tries to advise them. But, there's certain, we want to see where that addition is in relation to the neighbors. And, now again, we now have Google Maps and street views, and sometimes I've been more than content to say, look, here's an aerial of it. This tells you more than the site plan would, or let people come in with photographs either. So we're flexible, but we could, as you've probably seen, we sent people back and said, you need to revise this plan to give us more information. But yeah, that's one of those things where it would take sort of a major job to look at it and say what should really apply here for plan requirements.
Proposed buildings, we like to, even though it's not in the bylaws, we like to see elevated drawings. We want to know what it's going to look like simply for the town.
Yeah, and again, we're not a design review board. We can't dictate how it's going to look. You want elevated drawings just to know what the real impact on the neighbors is. That's, part of it. But again, sometimes when we ask for that information, it allows an opportunity for some discussion.
With the industrial area, the commercial condos, especially on Route 18, some of them have been built and been really crappy looking. Yeah. And that's really provoked the I won't say requirement, but kind of a subtle demand that we see and we'll make comments. I'm the one that likes to see a farmer's porch, or I like to see a nice facade, even though it's a commercial condo. God damn it, it's on Route 18, it's our town. You're from Hingham or someplace like that, and you're just gonna, you're probably gonna sell it anyway, as soon as it's done, as soon as you have everything leased. So we want it to look as nice as we can possibly have it look.
Yeah, and meet the character of the neighborhood. I think at 159 Auburn Street, where, there's the duplex,
Yeah,
and it's a single door, it fits the character of the neighborhood.
yeah,
I
yeah.
think that that's important.
Yeah, and if somebody needs a special permit, well, we can, make some demands about how it's going to look, because we get to decide whether and there is a provision in the bylaw that defines, what the grounds are for a special permit. But basically, we can decide that it's not suitable because of the way it looked. We had that with the 74 Franklin Street, was it? Where they had to come back here because they finished off the attic. But some of you may not have been on the board at that point, but their original plan when they came in for this duplex was like this, industrial looking building. And we said, look, we're okay having a duplex there, but we want it to look like a residential building. So they came back with a totally different plan. So that's where we were able to use, because that did need a special permit, might have even needed some variance. We clearly were not going to approve that original design. And we do try, again, it's just as a general thing, because I used to, be a lawyer and go around to different towns and work with zoning boards. And there were some towns where the zoning board, the way they operated, the applicant came in, made a presentation, no questions from the zoning board, closed the hearing, and they voted the thing up or down. And without any consideration to whether some modification would have saved the project in their eyes. And we just don't do that. We give feedback, and if it takes a continuance to give them another shot to come back with something that we can live with, then that's what we do. That's the way we operate. Because another reason is because there is a restriction. If somebody gets denied, they have to wait 2 years to come back, unless they come back with a different project. And who's going to decide whether it's different enough to come back? They have to go to the planning board and get the planning board's approval to come back to us. It just gets really complicated. So I'd much rather, and it has to be re-advertised. You have to inconvenience the neighbors to come back out for that second hearing, and there's delays. So I'd rather continue the hearing, try to work it out, than just shoot them down and send them on their way. So, any other questions? Okay. So we have a couple of things that can go to town meeting, should go to town meeting. And so one is the revisions to the accessory dwelling unit bylaw. So all zoning bylaws have to be approved by the Attorney General, who reviews them, just not to say whether they're good or bad, but just to see if they violate any state law, particularly the state zoning law, but it could be other state laws that they violate. So everything's kind of tentative till the Attorney General approves them. So in the case of the accessory dwelling unit bylaw, the Attorney General issued a decision, this is back in October, which approved our bylaw for the most part, but struck out certain provisions. And the provisions, none of them were a surprise, by the way, because I and town council had a conversation with someone in the Attorney General's office who'd done a preliminary review. And these are things that they had concluded statewide they weren't going to allow, most of which I think went beyond the spirit of the accessory dwelling unit state law, but that's the way the state agency, the Executive Office of Housing and Livable Communities, has interpreted the law. So the Attorney General's kind of stuck with that too. So the provisions the Attorney General disapproved are almost like deemed to be in our bylaw. If somebody comes to the building inspector and wants a permit, or comes to us for site plan approval under this, they get to our bylaw is no longer totally in effect. But if we don't change the bylaw, how does anybody know that? How does the building inspector know that? So it's really, I think, a good idea to amend the bylaw to take care of those things that the Attorney General raised. Did everybody print out a copy of what I sent, or do you have it on there? Okay. So I'll go through, and there's one of these that I'm actually adding, making a proposed change that, and see if this is agreeable with people. But I'll just go through them. So, and I did it in this form of a strike through and an addition. I can talk to town council about the best way to phrase it, but I just feel going to town meeting, if we say in section B, change this to that, or strike out this, without providing the whole text, people are going to say, what the hell's, we're just going to get a lot of questions. So I'd rather, if possible, present it to town meeting more or less in this form so they get to see what changes are being proposed.
So
Right.
right now, we're still operating under the old
No,
provisions, correct?
no, our new bylaw is in effect
It is in effect.
because the Attorney General approved it with the
Oh,
exception
okay.
of these particular
All right.
points.
Okay.
So that's the way.
Even though it says to address provisions disapproved. Okay.
Yeah, it's the provisions disapproved, not the whole bylaw. So this bylaw is now in effect, and that's why it would be very confusing if we don't get this put on the record. All right, so subsection B. We took the position, which I still think is the correct position, that the intent of the state law was allow you to have an accessory dwelling unit on a property with a single-family house. The state has taken the position, interpreted that statute to mean you get to put an accessory dwelling unit wherever there is a, quote, principal dwelling, which could be a 10-family house, a 4-family house, anything. So where we put single-family, the Attorney General says that has to be stricken out. So that's the first change. Instead of saying principal single-family dwelling, it's just principal dwelling. The state's position is that you can have an ADU, and we incorporated that in the bylaw. You can have an ADU in any district where a single-family house is allowed. And yet, when you come to this piece, they say, well, no, it can be any number of units. So don't ask me to explain that.
You say that a 4-family can have
An ADU, yes.
yeah, it doesn't restrict it, they took it away.
Yeah. So we'll just have to live with that. So that's out of there. And that's why we identify single residence A1, A2, and general residence, because those are the ones where residences are allowed. We had this provision that an accessory dwelling unit should have a minimum gross floor area of 400 square feet. They struck that out just as sort of I think they just generally take the rule that you can't do that in a zoning, but particularly that they said there's nothing in the statute that would allow that. The reason we put that in there was we do have a provision in our bylaw that an apartment has to have at least 400 square feet. So I thought it was reasonable to say an accessory dwelling unit has to have 400 feet.
Otherwise, you make an outhouse.
Yeah.
An ADU.
I mean, so that needs to be stricken out. Not a big deal. Not that many people want to build a 300 square foot ADU, but that's like a hotel room. Okay, the next change in section B, this is one that I'm suggesting that we put in there, which is where I say, except where an accessory dwelling unit is to be located entirely within the existing principal dwelling, you can have an ADU. An ADU requires site plan approval. I've been thinking that if somebody is going to convert part of an existing house to an ADU, why bother making them come in for site plan approval? They've had to come in for a special permit under the old bylaw, but that was because we're reviewing anything for special permit, and we wanted to make sure the owner understood that occupancy needed to be limited to a family member, and that expired when they sold the house. There was a chance to talk to the owner, even if nobody else showed up. But now that that's off the table, because you can no longer limit occupancy to family members, it doesn't expire.
You can rent it out.
You can rent it out. The fact, if they're not changing the exterior of the house, putting an addition on that might violate a setback or impact a neighbor, why make them come to us for site plan approval? So that's...
Between them and the building commission.
Yeah, the building commissioner still gets to review everything to make sure they conform to the zoning bylaw. But why have them come to us? So that's one I'm suggesting. Does anybody have a different viewpoint on that? Okay. Section D, and again, we had the wording single family, so we've crossed that out there. Of course, now it's the intent of that provision really was to make it keep the appearance of a single family dwelling, and now it's just going to keep the appearance of a dwelling, whatever that is. But be that as it may, all the Attorney General asked us to strike out the words of single family, so let's do that. Subsection F, this is a strange one. So the state ADU law said you can require one parking space except where it's within half a mile of the train station. So we put in there, at least one space shall be provided. If you want to provide two, okay, but at least give us one. The state looked at this and interpreted our wording to mean that this board might require them to have two. And I talked about it. I said, okay, so we'll cross out the words at least, or I put at least one so I could have one with a capital in its place. So it now says one additional space shall be provided. If they come in and want to have two, I think we can say go to it, or say no if there's a reason why we don't want them to have two.
And that
But-
says one.
That
John,
says
can we
one.
go back to B for a second?
Yep,
It says, in this bylaw that's marked up, it says site plan is required.
site plan is required for all ADUs, but I wanted to have an exception for an ADU that's within the
Inside.
existing structure without any additions or whatever.
But that didn't happen.
We didn't have that in the original bylaw.
Right.
We just required it across the board for all.
So all in-laws are required to come for site plan approval?
As of now, any...
And that's not gonna change, right?
Yes, it is changing.
Well, there's no, strictly speaking, no in-law. It's an ADU.
Right, are you gonna strike the site plan requirement, or maybe I don't understand?
No, under the bylaw that we passed, and we were thinking in terms of, well, up till now, you've needed a special permit for every accessory apartment. State said you can't require a special permit. So we said, well, let's require site plan approval to make sure they still come to us. But on reflection, so as of right now, every ADU has to come to us for site plan approval, even if it's within an existing house and they're not making anything up.
So you
I want to have an exception for that kind of an ADU.
So we will get to see any ADU that's built outside of the principal dwelling?
If they're putting an addition on the house, if they're using over a garage, building a separate building, that's still going to come to us. But if they're just cutting up part of the inside of the
And
house...
so we can't deny us a site plan approval, we can just suggest changes.
Yeah, again, as I said, site plan approval is, you can't really... And the state would be, I can tell you, the state would be even stricter about site plan approval for ADUs for not letting the zoning boards go overboard as compared to a shopping
What
center.
about setbacks to property lines for detached?
Going to get to that.
Is that even in here? I didn't see it was.
Yeah.
I thought they
We'll get to
scratched.
that. We'll get to that, yeah. Okay, so is that clear? I'm just proposing an exception where they're entirely within an existing house. Don't come to
It might
us.
just be the wording that might confuse.
If you have if you look at this and come up with better wording, that's fine. I decided to stick it in here rather than have a separate sentence. So take a look at and if you want to propose different wording that would be clearer, that's fine.
I'm fine.
And by the way, the whole point of this is once we've looked at this, I would like to have us take a vote to propose this bylaw amendment. That way I can submit it to like all zoning bylaws, it gets submitted to the Board of Selectmen. They refer it to the Planning Board for a public hearing, and we go from there. But I think it should be, when it goes to town meeting, it should be proposed by the Board of Appeals.
So, does this have to go to town administrator, who then kicks it up to the Board of Selectmen, who then kick it to the bylaw study committee, who then kick it to the planning board, who then kick it to us, and if everybody says yes to it, then it goes to town meeting?
Not even, no. It has to go to the Board of Selectmen, so it goes to, and under state law, it goes to the planning board. The planning board holds a public hearing and makes a recommendation to town meeting. Planning board, it still goes to town meeting either way, but the planning board can recommend yes or no. It also has to go, under our town laws, goes to the bylaw study committee for, again, a recommendation, not approval. So once we propose it, it'll go on the town meeting warrant. We could, if the planning board, after the public hearing, we could make changes to the proposed bylaw in response to things that come up at the public hearing or suggestions the planning board makes.
The Board of Selectmen opened the warrant this last week, and they're closing the warrant the 17th of February.
Okay.
So this should be put in
For May?
for the May.
Yeah, they close it.
They could make a placeholder though. They're not
Now,
going to
that's
print
what I'm
it.
saying.
Yeah. Okay. I will go right to them then to
There's
get a placeholder for this article.
There's a potential public hearing on the 40R
Okay. Which.
on the 14th of April,
Okay.
which is too late, but that's what it is
Yeah.
proposed.
Okay. All right. So I get back to this. So that was the change in the parking space wording, which I don't think changes the meaning of what we intended. All right, subsection G. We required, in our bylaw that we approved, we required that an ADU in an accessory structure, that accessory structure has to meet the setback requirements of a principal dwelling. My concern at least was you have a garage that's 10 feet from the property line, fine, nobody cares. You put an apartment on the second floor above the garage, why is that more privileged than the principal dwelling? Why shouldn't it? And the state says, well, the state's position in interpreting the statute, the ADU statute, is that ADUs are supposed to be as protected as churches and schools and farms and, anything you require of them that makes it impossible to build one, you shouldn't be allowed to require. So,
Or holier than a house.
exactly. The ADU, and we'll get to this in another couple of places, the ADU is sort of given privileges that the main house is not. Makes no sense, but that's how they're interpreting it. It's partly because of where they put the ADU statute into the state law. They put it into the same section of the state law that covers schools and churches and farms and other protected uses. So anyway, the Attorney General says we cannot have this provision. It's only going to be subject to the same setback requirements as accessory structures. So I guess we could make all accessory structures have the same setback as the principal dwelling, but that wouldn't be too fair to people. So G has to be struck out in its entirety. Which also means, by the way, the remaining sections the lettering has to be changed, but I couldn't figure out how to do that. And it has automatic lettering in the copy I have, so I just will take care of that. Okay, yeah, this is section I on the third page. The last sentence is struck out. Again, talking about how ADUs are more protected than existing dwellings. So one of talk about a non-conforming building is a building that was built, prior to a particular zoning requirement and doesn't meet contemporary zoning requirements. Maybe there's either it was built before zoning entirely, as many of our older houses were, or it might have been built, in the 60s, and then the bylaw was changed later to increase lot size requirements or increase setback requirements, and that structure no longer meets current zoning requirements. It's called non-conforming, as it's not illegal, but it just doesn't conform to contemporary requirements. But houses that are non-conforming are treated a little bit better under the State Zoning Act, and therefore for our purposes under our bylaw, than, say, commercial structures are. And one of the provisions is the way the courts have interpreted it. This is all kind of developed through the courts. If it currently, say you've got a house that currently violates a side setback closer to the lot line than the current bylaws allow, and they want to put some addition on that further diminishes that setback. Under the court cases, that doesn't need a variance. It just needs a finding from us or a determination that this isn't any worse than what they've already got. It doesn't substantially make it worse. So that's not required to have a variance. But again, under the court cases, if you have a house that meets a setback requirement and you want to put an addition on that violates the setback requirement for the first time, it needs a variance. It doesn't sort of get the benefit of the doubt. Again, the reasons for the difference between the two, who knows? I knew when these decisions came down as a zoning lawyer, my attitude was, I don't care which way the court decides it, but just make it cut and dry, because none of us know what the rule is. So that's the distinction they drew. In existing nonconformity, you make it worse, it needs a finding or determination. A brand new nonconformity needs a variance. Okay, so when I drafted this, I said, if you're going to put an addition on a house to allow an ADU, let's have the same rules apply that would have applied for the house, right? That seemed to make sense. Nope. That's the last sentence. The whole first part of section I explains that addition, extension only needs a determination. Here's the standings for a determination, etc. And then in the last sentence we said, but if it creates a brand new nonconformity, it needs a variance, just the way it would for a house. And the state says, nope. If you put an addition on for an ADU, you can't require a variance. So, even though you could require it if you put an addition on to add a living room, an extra bedroom to the house itself, that requires a variance. Put an addition on for an ADU doesn't require a variance. So that's why I'm proposing that sentence.
So does that say to go right up to the property line?
I think we can still apply the
Accessory. 10 feet?
Not if they're adding it to a house, it's still subject to the setback. I think we can still require a finding or a determination.
But you can't deny.
Well, that's the interesting thing, is again, because it's such a protected use, in theory, if we can only impose, and the state law said we can impose reasonable regulations. Well, what's reasonable? You know, letting them go right up to the property line when they don't really need to, they could do it otherwise. You know, that doesn't seem reasonable to me. So I think we can still use the determination finding procedure to jawbone these things, you know, a bit. But we can't outright require a variance. And we can't require a special permit. We can only do this through site plan approval.
So we can't really deny it, even if they want to go right to the property line.
Well, we'll find out. We'll see if we're going to stick. But I mean, the state did allow us to still require this determination. So,
But if you deny it, there's really no mechanism to deny it. We're doing site plan approval, you can't deny site plan approval because
yeah.
this addition goes 2 feet from the property.
But isn't your AD,
Well-
your auxiliary building's gotta be 10 feet? So can't you use that?
Yeah, I mean, I think we could probably say that. Well, why should, you know,
Yeah, so
why
site
should
plan
we at
approval-
least be able to require the same as we do for an accessory building?
So you're
How
saying-
is that unreasonable?
Right, you send it back to the drawing board, you
Yeah.
didn't deny anything.
Yeah.
But there's some guys out there that get pretty savvy at this.
Yeah. So we'll see what happens. But yeah, you know, it comes push and pull here. Somebody comes in for a permit and they want to build, and they know that if we deny it, they're going to spend 2 years in court before they can build. Then maybe they're willing to compromise. Right? You know, we have to think of those things too, but we'll just have to see what happens. And that's all the changes. I mean, it's not, you know, the big thing was the single family setbacks in the case of an accessory structure. So those are the main changes the state made.
Yeah, did I miss anything that had to do with more than one?
We cannot, more than one ADU. We have, did we put anything in here about a special permit for, under the state ADU law, we can require a special permit if they want to have more than one. I don't remember, did we?
I thought you had something in here.
I thought
It
so.
says in B, it says a single accessory dwelling unit is allowed. Single,
Right.
not two.
But I don't know if we said, if we're silent, they can't have a second one. Of course, if they have a 2-family house and they want to make it a 3-family and then have an ADU, or have an ADU and then make it a 3. I mean, we assuming it's a district where a 3-family house would be allowed, it didn't.
You know what's
Yeah,
weird,
sure.
John, is a dwelling unit that has previously received a special permit for use as an accessory apartment under provisions talks about it be considered allowed by right, the way it is. So my example is I have a special permit for an accessory apartment that's for Maureen's sister. There's no fire separation there, but if she leaves, now I can just rent it.
Yeah.
And that's not in compliance with the building code.
Well, that's something
We talked
we
about
don't.
that in a previous,
Did we?
yeah, and we said, let the state figure that out.
Yeah, but the building inspector.
Not that I ever wanted to rent
Yeah.
it, but it makes it so that I don't have to sneak. But
Yeah, the reason we put N in there, that very last section, was we just didn't want any.
that's
just
what they're
basi-
all doing.
we-
That's
yeah.
what the law says.
Well, if
Well,
you look
the
at- if you
law-
look at J,
Yeah.
excuse me, it says, any modification of a principal dwelling or an accessory, for the addition of an accessory dwelling,
Yeah,
it
I'm
must
not gonna
comply with the
modify anything.
regulations of the state building code, state fire code.
Yeah, and I'm not gonna modify anything.
It's
Yeah.
within the
It's already there.
But if the building inspector wants to deny
There's nothing.
And of course,
occupancy permit, yeah.
probably won't ever know, but if he did, yeah.
So it's smart if you're an ADU guy or you're a building official, if someone is contemplating adding a internal accessory, what do we call in-law, to put fire separation, when you do the work, in the event that they might want to rent it at some time in the future.
Absolutely, part of the documentation
Yeah.
that you need.
And that, I mean, and that raises the question, suppose somebody wants to put an ADU in an existing house, do they have to,
They won't get it.
is it going to be, is it considered, I mean, it should be considered as a second,
Or two-family.
a two-family, they should be subject to those building code requirements.
Fire separation is a fire code and a building.
Yeah, so they should be, but, and this, what we have here about this require, you must meet the state building code, fire code, standard, that I just took out of the state legislation, so.
But I had
That's
read this.
not our board's problem, you know. It's the building inspector's problem.
The other thing that is it a gap? How does the tax assessor know?
Building permit,
Is
it
it
takes a
building
permit, you gotta pull a permit.
Yeah, and a certificate, yeah,
Tax assessor.
if somebody wants to do an ADU,
Right.
yeah, and a building permit and certificate of occupancy, so, yeah, they'll know that it's a
Yeah,
second
they
unit.
already call my house a two-family, so.
Yeah, and I don't know what assessors have been instructed by the state in terms of, do you now consider, is a house with an ADU a two-family? It should be.
Should we have a sentence in here where it says any addition of an accessory unit into a structure or to an outside structure, must have a building permit must be issued? Or is that already taken care of, covered in state law?
Can you
the
think of
building
any
code requires
situa-
a building permit anyway.
Okay.
So-
Yeah, I can't, I mean, if you're putting it in an existing house,
If-
you must be doing some construction to make it happen.
Yeah, you need a permit.
Yeah,
So it's already covered in the state
Yeah,
law?
building
Yeah.
code already requires.
Yeah. yeah, and I wouldn't want to
And
put
then
it,
if you go in and see the building commissioner for that, he's gonna say, well, what's this for? Because it's got a kitchen and another bath. And they're gonna say it's for a ADU. Well, then the building inspector can't ask if it's gonna be family. Because
No.
if it is family, you don't need fire separation. If it isn't family, then it needs it. And
and even if they say it's for family, now they can rent it anyway, so
that's my.
the building inspector should impose the same requirement as if it were a
Can
two-family.
he ask those questions? I mean,
Should be able to.
the intent would be, no, I'm gonna have my family in there, and then you just do whatever you want.
100%.
Well, does the new law, does it supersede the existing in-law
Yeah.
provisions of the, and the existing, or the previous editions said you didn't need fire separation,
No, it's a
because
single.
it was only for,
It's a single family.
relatives. It was still considered a single family home.
Yeah.
But with the new law, does that make anything new now a two-family?
As soon as somebody occupies it that's not a relative, within third degree separation, then they are outside the family, and you're not supposed to have to know what they're up to over there. That's why the fire separation is required.
Now, there could be still some,
But even in the new language of the law, I read it and it said, it didn't say go to the building inspector, make sure it's going to be legal to be used as a second family.
now, I would note that ADUs to be, ADUs with capital ADU, is limited in size. It can't be under, and this we took straight out of the state law.
It
Gross
can't be-
floor, it can't be more than half the gross floor area of the principal dwelling or 900 square feet, whichever is smaller. So, if somebody wants 1,000-foot accessory unit, it's not an ADU. They'll have to go under, treat it as a second
And you can
unit, which may or may
require-
not be allowed, and
Second
whatever.
primary.
Yeah,
Yeah, but now that you took out the single family wording, if you have a fourplex somewhere that has four 1,250 square foot units, you could essentially build an ADU. It's 2,500 square feet.
Except how that it's that or 900 square feet, whichever is less. So they can't have more than 900 square feet, even if there's 10,000 square feet in the principal dwelling.
Okay.
They can go up to half, but no more than 900.
So if you have a three-family, you want to add on to the principal dwelling, make it a 4, that automatically triggers sprinkler.
Okay.
4 more
Yeah.
units require
Yeah.
sprinklers, and
Yeah.
I don't think anybody's going to argue with that. So
Yeah. Again, building code issue. Yeah, I think they're going to have to. It's a dwelling unit. It may be an accessory dwelling unit. If anything, we've kind of done away with
yeah, they
the
can.
confusion about in-laws. It's
Yeah,
it's
you
clearly
have
a
to-
separate dwelling
Yeah,
unit.
you have to comply with the building code and the fire code. The only thing I see is this fact that they've actually given a blanket protection for existing in-law apartments.
Well, this is something we put in, and
I know, but that's language right out of the law. It looks like it's the same.
no, we put this into because not all towns had an accessory apartment bylaw.
Right, but it says that any previous ones in the law, it says that any previous ones would be considered legal.
In the state law.
Yeah.
Really? Okay, I didn't remember that. Okay. I put N in there to avoid confusion about the ones that we had previously approved.
Yeah, I have to
We're just
read it.
fine. You're legal, don't come back to us when you sell the house, just go
Yeah,
on.
remember we got a 5-year on it?
Yeah,
75
yeah,
years in it,
yeah.
come back?
yeah. All right, so I would like a motion that the zoning board propose this bylaw amendment to town meeting and submit it to the Board of
I'll make a
Selectmen.
motion.
Okay, moved by Bob Curran.
Second.
Let me actually make notes in this.
Good job, John.
So if you put an ADU in an existing house now, you have to have fire separation, period.
Yeah, and that's easy to do when you're building it.
Right.
It's just 5
right.
sheet.
Yeah.
Okay, so you had a motion by Bob Curran, seconded by Bob Kimball. Any further discussion? All in favor, and I'll make it let's see, do we have all 5 members of the existing. Okay. The other thing I sent out was just as time has gone along, and really there have been like very few zoning bylaw amendments since like 1987. Because if we had a planning department, they would kind of be going over things, and every year there'd be a couple of zoning bylaw amendments proposed. But we don't have that. And the bylaw study committee has, I think, been kind of a passive in the sense of something comes to them, they decide, but they don't go looking for things to do. So we keep coming across these things and saying, geez, it should really be different. This is the one I remembered. You may have others. But did I send out a copy? Yeah, I sent out a copy of that. So when we have a provision in our bylaws, is in 12.5, that a special permit is good for a year. The reason it's put that way is because 50 years ago, when this provision was put in there, that's what the state law said. The state zoning act said towns may impose a requirement up to a year. Or, you can say it expires after a year. The state law subsequently was changed to make it 2 years. Then it was changed to make it 3 years, and our bylaw has never changed. So we can still, since the state, this is one of those cases where the state law is saying what we can do. So our 1 year requirement is legal. But if we want to allow up to 3 years, we can, but we got to change our bylaw to do that. And that's what I'm proposing here, because we have projects that have been delayed for financial reasons or other permits that they need from other boards, whatever. And so people have had to come back to us really unnecessarily, because if we approved it the first time, we're probably going to approve it the second time. Something's drastically changed. So I'm proposing to make it 3 years. Also, the new text that I gave you here borrows from the state law. Our existing law just says you have to exercise them with one year. What does exercising mean? Does it mean pulling the building permit? Does it mean actually starting construction? Does it mean finishing construction? Does it mean opening the business? What does it mean? And so the state law has this kind of wording about you have to begin it except for good cause. Or if it's for construction, you have to begin the construction, don't have to complete it, except for good cause. And I've also added the words here that the building inspectors are determining, because it's kind of, again, up in the air about who's going to decide what good cause is. Well, I don't want the zoning board, having them come back to us to decide whether it's good cause. It really belongs to the building inspector to decide whether to revoke the building permit because they're not doing anything on the property. So that's the reason for this wording here. It doesn't have to be 3 years, it could be 2 years. But I just feel like if the state allows up to 3 years, that's what we should do, so we don't have people coming back to us. We had this with the marijuana establishments. They weren't able to exercise within a year because they were waiting for the state Cannabis Control Commission to do its job. So they had to come back, and even before we did the change based on the new host community agreement, at least one of them came back and asked for an extension because they were bumping up against the 1 year, and our existing bylaw didn't make it clear, particularly the one on 356 South Ave, they'd started doing construction work inside the property. So why do they were exercised, they had acted on the special permit. But I'm proposing wording to get rid of the word exercise, because that's very vague, and have this provision. So just putting it on the floor, what people think of that.
I have a concern about good cause.
So
What
that's
is good cause?
and that's undefined in the state law.
Yeah,
That's a provision that if we don't have it in our bylaw, the state law still applies. So we might as well adopt that wording from the state law, or we just create, a smart applicant will know that that's the out in the state law, even though we don't have it in our bylaws. So I say, let's put it in the bylaws so they see it. But it's not, there have been court cases on that, it's not being able to get financing good cause. It's waiting for a permit from another board, good cause, yeah.
but for good cause, potentially somebody could drag this out for 10 years.
They could, but if you think about it,
So I've got a piece of property that I've approved, and it's on the tax roll, but the development isn't. And the person drags it out for 10 years, and I lose the opportunity to put it on the tax roll at a higher rate. Because the property's been sitting vacant.
yeah. But from our point of view as a zoning board, if we approve the special permit, a special permit is good forever, as long as it's carried out. Do we care how long it takes them to build it? Do we want them to lose the right to build because a certain period of time has gone by? That's the way I look at it, and usually the answer is no.
But I think they should come back before the zoning board and ask for an extension.
Well, we can.
That's my opinion.
Yeah, and so the problem is the state. Let me explain something. That with variances, there's a different rule. and this is in the state law, so we're stuck with that rule. Under state law, if you don't exercise a variance, whatever that means, within 1 year, you lose the rights to the variance, unless you come back to the board before that year has expired, and we can give up to a 6-month extension, but that's it. After that, they have to start over. So that's in the state law. State law has a different rule for special permits, and it doesn't talk about exercising them, and it doesn't allow for an extension. So if we had a strict cutoff and they don't meet it, they have to reapply. And go
So
back to
the state doesn't have a provision for an extension within a special permit?
No.
No, it says new hearing.
Yeah, and that's why the state has this good cause wording. That's sort of the de facto extension under the state law.
So I tend to agree with Bob. I think we're already set it at 1 year. Now we're going to 3 years, but now we're letting them skate off, and we're putting a lot on Jimmy.
Mhm.
I think they should come back to the board. You say 3 years, you missed that 3-year window, you come back and you tell us why.
Yeah.
Don't put it on Jimmy.
But if I have a special
Building
permit
commissioner.
and I have a variance within the special permit, they've got to execute within a year.
Yeah.
So
And again, what does exercise means?
does it mean
that
record the decision?
do you record the decision, or does it mean you have to, if it's a variance to divide the lot, you have to have actually divided and sold off the lot, or you started construction? There have been multitude of court cases about what it means to exercise a variance, more so than court cases about good cause for continuing a special permit. Usually the court case with variance involves a neighbor who didn't like the project in the first place, so any chance he gets to shoot it down, he's going to ask the building inspector to prevent them from exercising the variance. So anyway,
Well, I like the new text. The only question is 3 years correct? Is 3 years the right?
yeah, I think I'd say to Ed and Bob, I think we're stuck with the good cause language because that's in the state law. So I think right now, the only question is if you've done nothing there, you haven't started construction, and there really isn't something, good cause certainly includes something like what the Cannabis Control Commission futzing around with people is. Does it include lack of financing? I think a good argument can be made that it does, because of the way that during the recession and then during COVID, this legislature passed laws that extended all permits. I'm sure you ran into this with orders of condition, that the state law said, notwithstanding that they're supposed to expire, we're going to toll them and let you have more time to exercise. So I think a court would look at that and say, well, the intent of the legislature is to lean over backwards to let you carry out the project. So I think lack of financing, as long as you've actually applied for the loans and whatever, I think that probably applies. I mean, we could make it, except for good causes determined by the Board of Appeals, and make you come back and do that.
That's what I was going to suggest.
I think we could, because the state law is silent on that.
Yeah, instead of the building commissioner, I'm going
Okay.
back here.
Okay,
So,
I'm fine with that.
Good one.
I'm thinking anything with any site plan or any special permit that doesn't include a variance is going to be a pretty minor project, probably residential.
could be commercial.
It could be, but they seem to always need something.
Well, that's because our bylaws
Our bylaws,
say 100-foot setback on Route 18.
So I think with the 1 year we're covered with the variance thing. So I don't really have an issue whether it's 1, 2, or 3.
All right, so why don't we make it 3 years, but the good cause thing is to be as determined by the Board of Appeals. Make them come back to us. And that wouldn't necessarily have to be an advertised public hearing, because like when we grant an extension for a variance, we don't have to advertise that under the state law. That can just be done at a meeting, So I think we can interpret it that way.
That would be more comfortable.
Okay,
Yeah.
okay.
Now, you still only gonna get the 6 months
Excuse me?
when they come back to extend it? Are they still gonna get the additional 6 months?
For variance, yeah, for the special permit, which is what this provision addresses,
So the board,
that they come back in good cause, we can say, fine, you're good for another year, come back then if you haven't done it by then, whatever. You know, it's either, if it's a use special permit, it's opening for business, really, is what to me, that's what exercising the special, what carrying out the special permit means. If it's put up a building, then let's see what it means. Yeah, actually, as long as they've started construction, they're actually covered. They're covered without even showing good cause, because as long as they've started construction, they're carrying out it. But usually a special permit is, it's construction and use. If it's a commercial building, well, we're giving them a permit for the construction. We gave a special permit, for the warehouse, because most of our commercial uses are special permit uses. So they're still going to lose it if they don't open the doors. So, all right, so it'll be all the good cause wording then as determined by the Board of Appeals. Okay, I'm fine with that.
and one other thing.
Yeah.
The 40R has a 2-year.
Yeah.
In 40R it says 2 years.
Is it?
Yeah.
Okay.
Should that be changed to 3 years to comply with this?
I don't know, I haven't looked at the state 40R provision. Okay, but that's a good point to raise. There may be something in 40R itself, the statute that says 2 years. Yeah. All right, can I have a motion then to propose this amendment on special permit dating?
So moved.
Okay, second?
Second.
Okay, so Bob Kimball made the motion for the sake of the minutes. Bob Keeman, second it.
And Bob Curran voted for it.
Okay, all in favor? Okay, 5-0. Okay. Okay, other things beyond the two that I sent out, I'd totally forgotten about 40R. But and I didn't give you a copy of that. So that's the overlay district, more or less duplicating the MBTA district, but not including the areas north of Essex Street, but adding the Franklin Street parcel that may or may not be proposed for 40B. I haven't heard anything about that moving forward. So somewhat contiguous to the MBTA district, but with different requirements for setbacks and units, and with the provision the town gets paid some money from the state for approving projects in that. So that's been drafted, it's been submitted to the state, which has given some comments back, but I mean, it's more or less, I think, okay, I got I'm among the, are you among the people who gets this? That that came in last Thursday or so, I haven't even looked at it. Bob, we never took a position on that bylaw, so we're not the ones proposing it, but we may get asked at some point whether we're in favor of it or not. So I kind of throw open the floor. Bob, since you've looked at the latest piece of it, what's your reaction to it?
I didn't see it.
No, Bob Kimball.
Oh,
Yeah, no, it makes there's a few things in it that need to be tweaked a little bit. Like they have one thing that says plan approval projects within the SGOD, including residential, mixed use, and non-residential development. What's non-residential? There's,
Yeah.
and then there's another place in there that allows non-residential. Well, if it's non-residential, it should go back to the MBTA, or it should go back to the commercial that's underneath.
Okay. Because this whole thing's supposed to be about building residential units. So
Residential units.
yeah. Yeah, I remember I think you were there that night at the Board of Selectmen meeting where the question was kind of tossed out to them. Do you want to allow commercial on the ground floor and residential above, or do you want to make people use the mixed-use overlay district?
Yeah.
If they want to do that, fine, but and the Board of Selectmen, I think the attitude was allow mixed use under this, but not totally.
It's not clear in here.
Yeah,
The
you're
way
right.
I read this, they're not allowing mixed use on the main street, which would be South Ave, but they're allowing.
Where we should allow mixed use.
That's where it should be.
Right. And you get no credit for it too. I think it's $3,000 per unit
Right.
the town gets for every unit.
Residential units.
Every residential unit, right. I don't believe it says you're not allowed to to have commercial, but you just can't require it.
Right, and I think there was there's a limit to how much of the building can be
Well,
not
and
commercial.
there's some confusion in there because it says it's gonna be 51% residential, but can't be any more than 30%.
That makes no sense.
A little confusing.
Yeah. And there's confusion in that whole bylaw because they're trying to have like sub-districts within this district, like have certain kinds of structures allowed in one piece of this district and other kinds of structures allowed in another piece of the district.
It should all be one district.
That's the way I feel. That's like the planners taking over, kind of deciding how they want things to look and not, from a zoning perspective, we don't care. It's like...
No, I think the legislature in its wisdom puts out the MBTA district not thinking about it. They put out the ADU without thinking about it. They put this 40R out without thinking of the consequences. It sounds good because they want to make housing available, but the nuts and bolts of it they don't think about.
So the purpose, 40R gets another section of state law, allows towns to create these districts and get paid money. The idea was to give towns an incentive
Right.
to allow multifamily housing. For the most part, throughout the state, it hasn't been what we're doing here of sort of creating a district and say, come and get it. Usually these things have been a developer wanting to put some big development in part of the town and the town kind of cooperating with them and saying, okay, let's create a district which would allow this development and we'll get paid some money for it, which is, fine. But that's the way most of these districts have been done. And so in those cases, you know exactly what setbacks you want, how many units it's going to be, what it's going to look like, because it's all been kind of predetermined by negotiations between the town and the developer. This is more open-ended.
Yeah, and this doesn't allow single-family homes, where you could have a lot of land, say, you have 3 acres of land, and you put individual tiny houses on it. So you make the density, but they're individual houses, as opposed to houses that are combined.
Well, I thought you could do that.
No,
Not
not
a
according
40R.
not according to this.
I thought as long as you have a minimum of 6 units per acre.
Yeah.
As long as you have a minimum of 6, I thought you could.
No, according to this, the way this is written, they eliminated the single.
Yeah, but I think that was because of where we're putting this district. We didn't, again, 40R could be used for a resident,
Cluster.
cluster development, single family residential development, But because of we were essentially putting it in the same place as the MBTA, we're not looking for, 6 single-family homes to go in on industrial way. And we told them originally they were going to propose some sub-districts in like other parts of the town. We just said, forget about that.
Yeah.
Just don't even go there.
Well, the proposed townhouse units, they're on Franklin Street.
Okay.
Lenny King. So he's increased the number of units to 87, if I remember correctly. And he's still proceeding with the 40B, but he's doing that only because he needs a marker while this town pursues the 40R. He'd rather go 40R.
Yeah.
But in the case that the town drops the 40R, he's got the 40B.
Do you know if he's actually,
yeah.
did he submit it to the state?
The 40R or the
40B?
I believe so.
I believe so, yes.
Yeah.
Really? Okay, because I think I talked to Kathy Key from Mary Beth and said, did he actually submit it to the state? Because so I didn't know if
Well, how long ago did you ask on
a
that?
few weeks ago.
Okay. The last time I've talked to him was like the 15th, I think, of January.
So I think it was when he was before us. They said they were going to go ahead, figuring they're not going to get approval from the state till April or so, and at that point they'd be willing to see if town meeting passes 40R,
Right.
and if town meeting
and they
doesn't
can
pass
drop that
40R.
40B at any time.
Yeah.
The minute before,
Yeah. But I didn't know if they'd actually move forward with it.
I
'Cause when
believe they're pushing hard on it. They want to get moving.
Okay.
So,
Okay, I didn't know where that stood.
they want to get moving on it, and frankly, Mary Beth wants. She sees $3,000 times 87 units, and that's an immediate payment to the town.
But the problem there is, if he goes with his 40R, there's going to be, in them affordable units, there's going to be a number of 3-bedroom units.
Yes, there will be 3-bedroom units.
I never did come to Concom.
Yeah, well, to discuss it, yeah. I mean, when they came before us,
We recommended that they come before us.
you'd at least discuss it, but I guess really at this point, again, I haven't given you all copies of it because you see how long it is. It's really complicated.
25 pages.
Yeah, and partly because of these sub-districts, I looked at it and there's like this whole set of provisions, and then it seemed to duplicate it. And that was because they were creating sub-districts, and I said, don't have a sub-district, have the same regulations for the entire district, and you'll cut it in half and you'll make it less confusing. And I haven't looked at the latest version to see
I
what they
think they
do.
took that out.
Did they? Okay.
Well, the town administrator, she really wants this because again, it's all about dollars and cents.
Yeah.
She sees. We had a presentation from the Old Colony people. They're the ones that are actually going to walk through.
Yeah, they've been running this.
And he was coming up with numbers as high as like $1.6 million to the town potential, but more realistic potential, more like 850.
Yeah, I mean it's the whole district
the whole
is
thing got
built out.
But really, you should see 800,000. So anyway, she was salivating.
Anyway, at one point, Old Colony, the planners were sort of pushing for the planning board and the zoning board to endorse it, but that was when it was going to go to the state. And I just felt we weren't in a position to act on it at that point. I think we still aren't really.
I just think it's good that everybody on the board is familiar with what's going on.
Yeah, I mean, from my perspective, and the way I've kind of pushed it in any meetings with these people is basically, as much as possible, duplicate what we did for the MBTA district. Now, it's not entirely possible because it's 40R, the state law, has different density requirements and different setback requirements. And I honestly couldn't tell you whether you can build more units under 40R than you could under the MBTA district. I don't know. But that was my perspective, is make it as much like the MBTA as possible, and that way you can go to town meeting and say, this is just like the MBTA, except this time we're gonna get money.
And that's really
Yeah, because I don't think you can sell it as something else, you know? I mean, we got the MBTA district through town meeting, but that was before a lot of the controversy about it, and it was 11 o'clock at night. We got it through town meeting. I mean, I think we did the right thing, but nonetheless, I think...
But the 40R requirements are less stringent than the MBTA requirements.
In what sense?
In what you can build, and where, and how much, and all that sort of thing.
Meaning you can build more units than the MBTA?
I believe so.
Yeah.
Yeah.
Which,
If you can figure out a way to put it there, you can put it there.
Yeah.
Even with the wetlands.
I mean, you still have to meet the Wetlands Act.
No, you can't. I don't believe there's any you can impose on the wetlands at all.
No, it's the same rules. It doesn't override the Wetlands Act. No. I mean, it's intended also, 40R, to simplify the permitting. It's intended to have one-stop permitting. But we already do that in this town by having the zoning board do both special permits and site plan review. A lot of towns, you know, one board does special permits, and, you know, planning board does one, and zoning board does the other. So developers act ping pong back and forth between them. But that's not really an issue in this town. That's not what's keeping developers building here, you know, the permitting. But it's intended to be kind of a more sped up process, somewhat like 40B. And I remember there like time limits. And
The same 120 days if you don't act upon it.
So
120 days, it gets approved. And,
so that's sort of like 40B then. Okay, because like we, under regular zoning, once you open a special permit hearing, you have until 90 days from the close of the hearing to render a decision. So as long as you continue the hearing, you can go on forever. Whereas with 40B and now with this, there's a deadline for action. Okay, so that's sort of the incentive to the developer and whatnot.
I thought there was something in here that said you could continue it.
Yeah, with the agreement of the developer. But we don't need the agreement of a developer under a regular special permit proceeding to continue the hearing. We can just do it. All right, I'm not going to propose any action on 40R. We'll just see where that goes, but just to kind of bring everybody up to speed. And then, Dick, you had the solar battery.
Yeah, so the town does not have any zoning currently in regards to solar and battery energy storage, and it's an item that is coming up in more and more in towns in this state because of the Beacon Hill, and they're wanting this green energy. Well, of course, you can't get green, you can't get solar at night. So what do you do with the anyway? So these battery units, they're basically, they look like container, like 20-foot containers or 40-foot containers, whatever they are, and they're filled with batteries.
Very hazardous.
And they put them, and that has been a concern, but as I understand now, they have not had any issues with them anywhere. And even Garino, is he still the fire chief?
Greta?
Greno? Who's the fire chief?
Forgetting.
Anyway, the fire chief, he's on board with it. He has no problem with it. Anyway, so the town is out in front of any proposed development. It's been recommended that we establish bylaws, and there are model state bylaws for two reasons. One, to prepare the town in the event a developer wanted to site a battery storage facility. and two, so that if the town was amenable to it, we already have the bylaws in place for a developer to bring a proposal to the town. Now, the economic, I'm on that economic development committee. Town wants to figure out how they can get more money without having to tax people. And so we're looking at establishing a solar field at the on the DPW and potentially battery storage there. We think that would be the best place in town to do it, the place the least amount of disturbance, that kind of thing. There was a very major proposal that was brought to the town by a developer last year on Auburn Street. You know where that big subdivision is there, Auburn and 27? That big electrical substation. Developer wanted to site a battery storage facility there. Now, he ultimately did not go with that location. He went somewhere else because that other town was already ready to go. But a good sized battery energy storage facility, it doesn't pay taxes, it pays fees to towns, usually for 20 or 25 years in lieu of taxes, but can be $1 million, $1.5 million a year. These are big dollars to towns. Duxbury's going through it right now. They have a big proposal that they're fighting to keep it out.
Yeah, so here's a little bit of background to this. Solar energy is another protected use under the state zoning law, like schools and churches and so forth, and ADUs. And so there was a recent court case which essentially said, if you don't have a district in town, a zoning district, where these, well, first it decided that the state law was intended, I think, to cover solar panels on houses. You can't prohibit solar panels on houses because we think they're ugly. Okay, so it was intended to protect that kind of thing. It's extended to things like solar arrays. But there was a court case where the court said, I think it was a land court case, that if you don't have a zoning bylaw that allows a reasonable area in town to put these things, they can go anywhere. So if we don't have a solar battery storage bylaw, and the court case said these things count as solar energy. So if we don't have a bylaw, any other town doesn't have a bylaw, you're really vulnerable because they could propose putting it in the middle of a residential area. So that's another reason to have such a bylaw.
This is what the battery storage looks like. These containers, and they're filled with batteries, all but the middle two doors on both sides for all electronics and everything else, but all the other ends are just filled with batteries. And all it is on a slab, and it's just like a Conex box,
They act like water tanks. They fill up during the night when nobody's using the electricity on the grid, and then during peak hours, the electricity is passed back to the grid.
The other thing is with the batteries though, the batteries for the electric companies are more stable because the batteries feed the grid. They charge the battery and everything else, but the battery is what's feeding the grid. So they can say, okay, we're going to have X amount of watts of power coming in. We did one up in Maine on a very sunny day, beautiful day. It was putting out 5 million watts of power. Cloud would come over and it would drop to 2 like that.
Wow.
And how does the infrastructure for the electric company go? All of a sudden you're getting 5, now you're getting 2, back up to 5. It's all relative on, the sun. So the batteries, like I say, they charge the battery, and the batteries and like I say, when there isn't sun, all night long, they still have the ability to put power back into the system.
Yeah, so as compared to actually what you said, Dick, I mean, I envisioned it as being sort of in conjunction with solar energy and even wind power, that's particularly with solar energy. So if you've got a solar field and it's only generating power during the day, that it gets connected to these batteries to store the power so it can be used, on a cloudy day or at night or whatever. So, it kind of makes,
The solar field is an option.
yeah,
You don't have to have the solar field.
yeah,
I'll just say Justin was thinking about proposing that the old ball field, the old soccer, behind the town
The community.
garden, the community gardens,
Yeah.
that become a solar field. I'm not in favor of that, but and you get very little. The town gets very little return on solar fields themselves from the developers. So, but it's kind of all part and parcel to how the zoning
Yeah.
goes.
So how do the batteries get charged if it's not a solar?
They're on the grid. They're connected to the grid, and they're charged either from solar panels or they're charged from the grid at night when there's a low usage.
That's interesting.
Yeah, the old pump storage out in Montague, they take it.
Yeah, essentially it's-
Pump it up to the
Yeah.
top of the hill at night and put it back down.
That's why it's like a water tank.
That's a
Yeah.
big water tank.
yeah, it's the equivalent of hydroelectric storage,
Right.
but for,
So I just thought it would be, since we're talking about
So-
zoning, something. So what we did was we voted to kick it up to support moving forward with some sort of bylaw, energy storage system bylaws. And so we kicked it up to Mary Beth. She's going to bring it to the selectmen. They have to bless it. And if they bless it, then it goes to the bylaw study committee. And if they bless it, then it goes to the planning board. And then if they bless it, it goes to us. And then if we bless it, it goes to town meeting. That's how I understand it.
again, I don't think the bylaw study committee,
No,
That's what
It-
Justin said. It had to go to the bylaw
but it's
study
gotta
committee.
go there.
well, it might be,
Well,
is this a zoning bylaw? It will be,
Yeah.
right? Because I mean, I don't think the bylaws because this is sort of a matter of state law, goes to the selectmen and to the planning board. The fact that we also have a bylaw study committee is sort of a side,
It's a
side
side
thing.
thing. They review the
yeah,
zoning bylaws usually after the public hearing of the.
yeah,
Oh, okay. So
yeah,
So it can be done
yeah. But are
in
they,
conjunction with.
so do they think they can do that for this town meeting?
they're going to try. They're going to try, but I haven't seen it on the selectmen's agenda, so I don't know how they'll get it unless they do what you're saying. Just put a place card in.
Placeholder.
Yeah, because the planning board only needs, a month or so.
Right.
In theory, if the bylaw is sent to the planning board, as late as March or, late March, it could, the planning board, it has to advertise the public hearing. The planning board can hold the public hearing the day before town meeting, but then it doesn't allow any time for actually revising it.
Right.
Yeah. We went last year when we were doing the ADU bylaw and we were pushing to get it to the planning board by January. The reason for that was to get the first newspaper ad before February 1st, because that's when the state law was going into effect. And by getting it advertised before February 1st, it sort of put it into effect, even though town meeting wasn't going to vote until May. So that was a special case. The amendments to the accessory unit bylaw, I'll get it to the selectmen and everything, but that doesn't have to be advertised by the planning board until before town meeting.
So that file that I sent you, it's a PowerPoint presentation.
Yeah.
It's like 30 pages, so I wasn't going to print that thing out.
Yeah.
And it's real slick for an engineering company, but there was actual, and I didn't realize.
So this is like a model bylaw the state is providing
But
to
what
us.
I sent you tonight was the actual model bylaw from the state that looks like this.
Okay.
And then we could take that the town can take that and use it, tweak it as needed.
Yeah. The town, at a minimum, the town's going to have to go through it and get it numbered to fit our
Oh,
code.
yeah.
And who does it say? Is it a special permit? And does it have the zoning board doing the special permit? You know, that it's going to be a little bit of work on it, even if it's a model bylaw.
Yeah.
Yeah. Okay. So that may not come back before us before May. All right. And are there other bylaw provisions that, like the special permit timing thing, things that have we sat here and said, geez, that provision's out of date.
Do we ever want to touch the workshop lot?
That's right. The
The retreat lot?
retreat law provision. So again, to bring everybody up to speed, I think we had one of these a few weeks ago, but just to go over it again. Town meeting allowed, a number of years ago, town meeting voted in favor of bylaw to, if you have a piece of property, you can kind of cut it up with a small amount of frontage on the street and have a house behind the main house on the street. So we call it a pork chop because that second lot looks like a pork chop. Okay. The Attorney General disapproved it for some technical reasons. The town bylaw put something in there about this only applies to lots created before such and such a date, and
It had to be an ownership of a certain period.
yeah. So the Attorney General threw it out, and town meeting, again, lacking a town planner or anybody pushing it, never went back to town meeting to try to come up with an acceptable version. But people come to us with that situation. We have generally granted variances to allow those lots to be created and have that second house, as long as they have the same provisions that were in the bylaw that town meeting voted, which had to do with that second lot had to be a certain size, you had to have greater setbacks.
Twice the setbacks of the
Yeah,
regular setback.
great, bigger. So the idea was to meet that. So people who have come to us for that, we've generally approved those, saying, well, that was the intent, and required a variance. So there we are granting a variance, and there's no provision in state law for that, right? But we said, well, that was the intent of town meeting, but geez, we really should have that bylaw fixed, and then we've never done anything about it. So
Since we're on the topic.
yeah,
Is that, as an example of that, the Franklin Street?
yes, yeah, we did that Steve Egan's thing on Franklin Street. Where the house is up, and there was another one. There were a couple of others. Yeah, there was one closer to downtown, like near 74 Franklin Street, that we approved that Steve Egan's already put the building up. And then there were a couple further up towards the high school on the other side of the street, those big lots that run all the way down to the railroad. And we approved a couple of those, and I'm not sure if they're...
But we denied the one on Washington Street.
Yeah, what was that one? I don't...
Across from Little Comfort,
Okay, yeah, and I think that was one where
the
neighbors were all up in arms about it. There was some issues with the ownership and everything too. So yeah, so we're not, we don't have to, but we've tended to approve those. The intent of, in most towns anyway, these pork chop lots is you wind up with fewer houses than the width of the small frontage on the street is the same width as for a subdivision road. So we're allowing them to build one house back there, whereas if we didn't have this, they could put a subdivision road and have 2 or 3 houses back there. That was the intent of it in many towns. But again, that's okay. Maybe I'll try it before the February 23rd meeting.
Sure.
Let me see if I can.
Yeah, we
I'll have to
usually
try to find the wording from the original. I think I've got a copy of the original bylaw.
Try to put a placeholder in on the
Yeah.
meeting.
And there are all kinds. I mean, you sort of have to decide strategically. There are lots of things I'd like to see changed in the zoning bylaw, but they're more substantive and would be more controversial, and particularly 40 Rs going on there. maybe we don't want to deal with the retreat lot at this one, just leave it alone. But it is one of those things where every time it happens, we sit here and say, oh, geez, we should do something about that. So thank
Of
you.
all the ones we have to do, that's probably the easiest one.
Yeah. As long as we can explain it to people sufficiently.
But as long as you're there, because you do a good job at time meeting explaining it,
All right.
they're just unanimous.
Yeah. Okay, anything else?
I had
Alright.
a couple of, hopefully that you
Yeah.
indulge me for a little bit. I had 3 stickies. First, I want to say I really appreciate what this board does. I really had no idea. And the zoning bylaws, I think they're great. It gives a really good roadmap for this board. What I can tell you is that being on Concom, we don't have any bylaws. We have the Massachusetts General, the Act, the Wetlands Act, but it's high level. It doesn't really set out requirements for the town and what the town expects. So one of the things that we're doing for the Concom is we are writing bylaws that we want to try to get on the warrant for May. So really appreciate it.
That'll be a controversial
It's
one.
because the stuff that comes in front of us, I mean, I really appreciate what you said too. You can draw a hard line or you can be collaborative and work with the developers and all of them so far. That's the way you approach them with that.
So towns have their own.
Yes, towns have their own bylaws.
Oh, yeah. We're one of the few.
Generally they do it to be stricter than the state law.
But the other piece is consistency.
Yeah.
So that everyone has the same roadmap. This is what you can and cannot do. Right now, it's not. It's kind of subjective. And we work with the developers, and it's a collaborative, opportunity. Like you say, like you're saying, what's good for the town, let's do what's right. But it will help the board going forward and help us too as we're navigating, developments and structures that are coming in, especially when there's impact to the wetlands, which there is. A lot of these things that come in front of us, and it's like, okay, there's nothing that says you can't.
Well, the engineers say it's all.
Yeah, everything's good. Don't worry, but your building's going to sink after 5 years. Anyway, so I want to let you know that the Concom is writing bylaws
Okay.
too. There may be some overlap with the zoning as well too, and maybe we got to figure out how to navigate that, whether to reference yours or what the zoning ones. So we'll have to figure that out. The other interesting piece is over the last year we've been working on an open space plan for Whitman and for passive recreational and conservation use. We had a lot of opportunities to talk with the public and get input, and we wrote up the plan. The plan was sent into the state, and has to get approved by the state, and it was conditionally approved. There's some minor tweaks that we need to do with it as well too. One of the comments that has come back is that the zoning maps, because we had to provide zoning maps, the zoning maps are not currently electronically updated. So the maps have hand edits on them. So the question is coming back to us, all right, what's the plan? How come they're not updated? So the question that I have is, should we somewhere in the zoning bylaws, should we say, put a plan in there that every 3 years, the electronic zoning maps have to be updated? So there's a timetable.
Yeah.
Because it's been some time and the questions are being asked, when are these going to be updated?
Okay, even worse than that. This zoning map that we've got in the back of our book is not accurate. Even though it was done in like 2004, I don't know what purpose it was done for, but, and this came up with that lot on Temple Street near the Cumberland Farms that Ron Whitney represented the applicant on. And we had a lot of confusion about what district it was actually in. And I think we worded the decision to cover, here's what you're allowed to do, we'll forget about what district it's actually in, whether it's this or that, it needed a variance either way, here's what you're allowed to do. Well, so there's a whole section along Temple Street that is shown as A1, and it isn't. It's either general business, a general residence, it's something else. And this came up when we were having the meetings in the 40R, one meeting I attended. The Old Colony people discovered this. This map does not match the map that's in the planning board's office. That map is correct, as far as we know. Because that map has a date on it of 1987, and as far as we know, there haven't been any amendments to the zoning map since 1987.
Except the overlay districts, which I know.
Except the overlay district.
There's a map that's dated 2014 or 2015 though. I forget where I saw that map.
Yeah.
But then again, this open space thing, a lot of the figures that they have, they are completely wrong.
Yeah. So anyway, so Old Colony is,
They give 8. They've got places that are residential, that aren't residential. They got places that are industrial, that are residential.
From a zoning perspective.
From the zoning, yeah.
Yeah.
Well, not the zoning map, but usage.
oh, the usage, right,
Yeah.
okay. But anyway, Old Colony is going to work on digitizing the zoning map and making sure it corresponds, that it's correct. Corresponds to what the planning board has. And apparently the assessors' designations are correct.
No, they're not.
Not,
Land use.
okay. All
Land
right.
use codes?
Not land use, but for zoning.
With zoning, but the lots aren't correct.
Okay. Anyway, that Old Colony's going to be working on that.
Well,
So-
we have to
so
get
once
a grant
that's-
first, though, right?
Yeah, excuse me?
We need to get a grant first.
Yeah, but they think they can. So once that's done, Ed, I don't think there needs to be a zoning bylaw provision saying updated every 3 years, because every time, if there are changes to the zoning map after that date, first it'll be very easy to change it, and it'll get done right afterwards, just like, the bylaws. It may take a year to get it online, because of the contract with the company doing it, but it should be, I mean, the zoning bylaw requires the zoning map be maintained, it's on file with the town clerk, etc. There is a provision of that. So I don't think we would need to have a separate thing requiring it to be updated every 3 years, because it needs to be updated every time there's a zoning bylaw change.
Yeah, I figured I'd ask.
Yeah.
And I
That's,
know it does cost the engineer.
but I'm glad you raised it, because that is, it's been,
So it's causing a little
Yeah.
consternation for us, but I
Yeah.
mean, it is what it is.
Yeah.
It's good if, now that I hear the planning board has a more accurate drawing, we can.
but still,
we can use
if
that
you're
for-
a
It's not gonna
developer,
happen overnight, this needs to get,
yeah, if you're a developer and you want to build in town,
You want to know?
you shouldn't have to
Yeah.
walk into the planning board office and look at this one map on a wall to find out what district your property's in. It was just nuts to me until we finally got the bylaws online a few years ago, and again digitize them so they can be easily changed over time. But I remember having a meeting years ago about what can we do to encourage commercial development in the town. Well, you could start by having an easy way for developers to know what the zoning bylaw is. That's one thing to decide what town to build in is, well, let me go online and look up the zoning bylaws, and you couldn't do that for Whitman. It's crazy. So at least that's been done, and now hopefully the map will get done too.
that's good.
Okay.
Then with respect to Article 7, site plan approval, I guess my biggest frustration, in not just here, but also on the Concom, is there's no real teeth. And when someone violates a bylaw or violates a law, there's no compensation. There's no fining. I really get frustrated about it. And what comes to my mind is beg for forgiveness versus asking for permission.
Mm-hmm.
So the thing that drove me crazy on the Auburn Street, because I get enforcement orders to shut down that project 3 times. And yet they come here and they're putting in a bedroom upstairs. Take it out. It wasn't part of the approved design. So I know I'm mentioning it now, but just in general, you see that. You're not following an approved design that the zoning board said, this is what you're going to build, this is what you need to adhere to it, and if you don't, in my mind, there needs to be a penalty. There needs to be some fees paid to the town for not paying for not following the approved plan. And I don't really see that in the zoning bylaws.
Yeah, really, the only financial penalty you can impose is the building inspector can impose a fine of like up to $300.
I didn't see that, but
That's a matter of state law.
And the courts don't care about the fine. They will get you to comply, but they don't care about the fine. They won't collect it for you.
Yeah.
when you say they'll get you to comply, the person that's building, so if it wasn't approved, you
Yeah,
gotta
if
pay
you
out.
bring, I used to go to housing court all
Yeah.
the time, and I had zoning violations. I probably went more than 150 times, and I'd see fire, and I'd see conservation, and they coming in, go to housing court or whatever, and they were all about compliance, not about money.
Yeah, which
And then if you have to go
is
to
even
court,
better.
if you have to go to court, it gets ridiculous. Now you need town council with you.
Mhm.
Yeah. I guess, but that's my biggest frustration.
Yeah.
Because it's ask for forgiveness.
I do think, I think we've learned this lesson a few times particularly over the last year or two. It didn't seem to be as much of a problem before. Is we have to be really specific in writing our decisions about what it is we're approving. We got to, reference the particular plans that have been shown to us and make the decision really clear that
What
This is the-
decision has this board ever made that says you can't finish the attic and the third floor? There was nothing, ever.
right.
We approved so many bedrooms.
Yeah,
And they-
but we weren't always specific about saying that as a condition of the decision. We had somewhere in decision that the applicant told us it was going to be a 2-bedroom unit.
It doesn't.
But we
fall-
didn't used to put in a condition that you are limited to 2 bedrooms. And sometimes then that fell through the cracks, particularly when we've had, different changes in building inspectors and whatnot. And frankly, if it wound up being in court, I'm not sure a court, our argument would be, that's what they told us. It's in the decision because it's in the write-up, the narrative of the decision. But a court might very well say, well, you didn't make it that's just, there was chatter back and forth, that doesn't count. Your decision is that paragraph at the end. So I've been trying to be more conscious of that now and be more specific about what we're allowing, reference the plan that we were shown.
And I found that doing enforcement, you'd remember what the board said, but it wasn't in writing.
Yeah.
So you couldn't enforce it.
Yeah. So we're just having more problems with that than I think we used to have, honestly. So
So is there something in the bylaws that we should add in the event that the site plan wasn't adhered to?
I think you just have to put it in the decision that, this is we've approved this site plan, or this, architectural plan and reference it. And then that it kind of puts the building inspector on alert to be more conscious of it and gives him some muscle to,
If you
require.
grant a variance, say for Auburn Street, we could have said approved according to the plan submitted by the owner, and any deviation from that whatsoever
Requires
require
coming
another
back to the
hearing.
board, yeah.
And then you could get them on that and say, no, take it out.
I
Yeah.
like that.
And, again, we didn't,
But people they're not stupid. They
No,
just
no.
don't think you're ever going to look at it.
100%.
yeah.
100%.
And I don't know, but you can tell us how would it, even if the building inspector understanding is that it's to be a 2-bedroom, at what point in the inspection process is he inside the building and say, wait a minute, what the heck are you doing up here?
Yeah, and they don't have the ZBA decision with them.
Right, well, that's what I'm
Right,
saying, yeah, they don't
right. But
have-
how often do they even
I don't
visit
even,
the building?
typically you don't have the house plans when you go.
Yeah,
Sometimes I used to look at them before I went out
yeah,
for an inspection, but as long as it met the building code, it was safe, that's
Yeah,
really what we
yeah.
had.
And how often do you inspect the house while it's under
And I don't
construction?
think zoning can restrict the interior space of a dwelling unit. I don't think you have the right to do it, unless it's under the guise of a variance, and then you can say, it has to be built according to the plan submitted.
Yeah,
Otherwise, you need to come
yeah,
back
yeah.
here.
Or, and if it's a special permit, we can
And you can do that in yours. And if you go to court, conservation goes to court, they win. But you become the bad guy and you have to start fighting. State law, DEP will help you with that.
Yeah, they will. Yeah, although a lot of times DEP kicks us back to us. They
Yeah.
give us, oh, here's what you
A lot of times if you're too strong on the public, then they go for a superseding order. And that's not
right, and that's not a good thing. Yeah. we
Yeah,
don't want that.
yeah,
Right.
yeah.
So, but I like what you're suggesting. Is that something? So on the decision, is that like a boilerplate?
No, I mean,
It's just
No,
what gets talked about here.
we talk about it here.
Because in my mind, I was thinking,
Cal and I kind of incorporate, but we, I kind of focus on the specific conditions, and we tend to think what they're telling us is what they're going to do, And lately, I think frankly, we're having a lot of people now doing development who are not professional developers. Some like, Steve Egan or Richard Rosen told us what they were going to do. They're going to do it. If Stop and Shop, is going to build something, you got an engineer. If you have an engineer who has to come to us over and over again, we know who they are. Kyle Garvey or whatever is presenting a plan. We don't question the plan, much. People you're familiar with. The same thing with the Concom. If you know these guys, their reputation's on the line. But we've had a lot of people who are brand new to development or construction, and I think that's where the problems arise. They're not going to be back before us again, so they don't have that incentive, and they don't really have the knowledge sometimes to even think that something's an issue when it is. So we got to be more specific.
But we have been getting much more specific in our.
This board has gotten a lot better.
Yeah.
And in the
Decisions a lot. I mean, you go back and look at a decision from 25 years ago. It was like a couple of paragraphs.
so I like your suggestion. Thank you. So maybe we just make sure we
You can just spell it out and say, if you don't do it, this is what's going to happen.
Yeah. And that's one of the reasons we like to have the building inspector here for meetings, and always happen with Bob, and it's happening with Jim, it happened with Robert Corelli. It's we turn to them and say it's okay. Often Bob would say to us, hey, you got to be more specific. For me to enforce this, I need to know exactly what it is you're requiring, and we make the conditions more specific.
The other observation for me too, I just got a couple more. Yeah. The other observation for me is I have a new profound respect for the building inspector because I'm on Concom and we don't have a conservation agent.
Which is
We're all volunteers, but I'm out doing inspections all the time, but I don't get paid for it. And I look at this and I'm like, wait a minute, Jimmy's, and you have to do all this along with all the codes? Are you kidding me? For one,
that was the biggest part of the job.
person?
Yeah, zoning was the biggest part of the job.
That's, wow. That just blows my mind. So thank you for your past service for sure. I totally get it now. So I was going to talk about enforcement too, but it just blows my mind. So in section 7, we're talking about the site plan. Mm-hmm. One of the things that we talk about what needs to be on the site plan, it would be good if we could add in that the 100-foot buffer zone. We may add it into the conservation that if you're already, when they go to do the site plan, they're going to be looking at this. So it might be better to list out that the 100-foot buffer zone needs to be identified on the site plan.
Yeah.
A
And if
lot of them do it.
a lot of them do it.
It says
if there's any that
wetlands needs to be delineated.
it does, yeah, the 100-foot buffer. But what we're now seeing is that people are building 25 feet from the wetlands. So when they come to us, they got the 100. I'm like, wait a minute, you're right up against the wetlands. We make them go back and put 50 and 25. So one of the things that we're talking about doing is making sure that the 100 foot is on there. And if any structure is within 50 feet, within the 100 feet, put the 50 foot. It might be better just to have it in the zonings because they're going to look at this. You know what I mean?
Yeah, I mean, we certainly, and this is one reason for local bylaw, I don't know if it's one of the provisions you're looking at. So under the state act, any project within 100 feet of wetlands needs an order of conditions. but it's not prohibited to construct within. You can go right up to the boundary of the wetlands as long as you get an order of conditions that tries to make sure you're not damaging it. In fact, you can go in the wetlands to a certain extent depending on the project. And a lot of town bylaws are stricter than that and say you can't build at all within 25 or 50 feet of a wetland. And that's one of the controversial things with local wetlands bylaws. Why developers don't want them, but why towns do. So we always, if there are wetlands on the property, the developers delineate them. If I don't see them, I almost always ask, are there any wetlands issues in this property? And certainly we always say to them, if they're proposing something, it's very rare that they propose to build in the wetlands, except like something that, again, if it's a developer knows what they're doing, like Steve Egan's over 55 needs to cross the wetlands to build the road in. Well, you're allowed to do that under the state law if you do this, that, and the other thing to mitigate it. Okay, so he's going to do that. But, if it isn't, I will always ask if I don't see something, are there wetlands on the property? But otherwise, if they're, closer, with outside the wetlands, I just, again, say, now you're going to the Concom, right? Because we don't really have any jurisdiction to do more than that. So.
I'm just suggesting in that where it says what needs to be on the plan, maybe it'd be better to have
that if we're requiring them to look at the wetlands anyway.
Yes, buffer. But the 100-foot buffer.
But look at F. Buffers and all landscape. So it's already.
Yeah, but
that's landscape buffer. Landscape buffer.
Yeah, so what we're looking at is the 100-foot.
Yeah, and your point is really, if they're delineating the wetlands anyway, it's just a matter of math to draw in the 100-foot line too.
And put a 50-foot if you're putting a structure within the 100.
Okay, all right.
Are we good?
Yeah, I think, thanks. You've been longer than a regular meeting, but
I said this would be a quick one.
Yeah.
Bylaws, never is.
All right, can I have a motion to adjourn?
Motion.
Actually, I probably don't even need it. I'll declare the meeting adjourned at 9:12. Thank you.
I'll see you guys again.